Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sydney Whelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Law Days and Lattes. Welcome to Law Days and Lattes, sponsored by the Whelan Law Firm of Moberly, Missouri, your go-to source for legal issues encountered by your family and your business. If you have questions about anything we discuss on this podcast, please reach out to us at www.whelanlaw.com. Our goal is to serve you, your family, and your business professionally and with the utmost compassion and understanding. I'm your host, Sydney Whelan. Welcome to episode number 17. First, let me tell you that I love estate planning. I would much rather help my clients reach their goals and prevent problems down the road than to try to fix the problems that have gone haywire. It's so sad to see and talk with family members and other intended beneficiaries in my office after a death, when they know their loved ones thought everything was in place to prevent probate and to easily take care of the affairs after they passed. There are hundreds, if not thousands, of examples of estate plans that did not go as planned. Examples of well-meaning folks trying to do the right thing with their estate plans, from the simple to the complex. Today, I want to talk to you about 10 areas where I commonly see estate plans go wrong, with the hope that we can all learn something from these examples. So, today's top 10, not necessarily in order. 1. Choosing the wrong executor. I'll never forget that call. It was a Friday afternoon at 4 o'clock. I got a call from a gentleman who introduced himself as the president of the local bank. He had called to let me know that my client, who had been appointed the personal representative of a fairly substantial probate estate, had, that afternoon, attempted to transfer $300,000 from a probate estate account into the gentleman's personal account. Fortunately, there were procedures in place at the bank, and this transaction raised some red flags. The transaction was reported by the employees, and safeguards were instituted to freeze the account until authorizations could be verified. The bank officer did a quick research on CaseNet and learned that I was the attorney for the estate, and he reached out immediately to both alert me of the potential risk and to ask questions. You can probably guess the first two questions. 1, did I know that the personal representative had done that? And 2, was the personal representative authorized to do that? Well, the answer to both of those questions was a resounding no. I certainly was not aware of the situation until that very phone call, and of course, the client had no authorization to move those funds into his personal account. Thankfully, the quick action on behalf of the bank prevented a disaster for the remaining heirs and beneficiaries in that case, and we were able to get appropriate court orders to ensure that it did not happen again. 2, ditto for naming an agent on your power of attorney or naming a trustee on your trust. It's so important to pick the right person. A power of attorney often has very broad powers to allow your agent to take care of multiple issues if you're unable to do so and are still capable of directing those actions. If the person you name goes rogue, it can be very difficult and time-consuming to undo their unauthorized transactions. As for trust, remember we call it a trust for a reason. You must trust the person you name as your trustee, or they shouldn't be named at all. For the most part, there is no judge or other authority directing the actions or overseeing the actions of the trustee. If you have any reservations at all about the person you are considering naming as your trustee, talk it over with your attorney. An experienced estate planning attorney will help you work through your concerns and suggest other options that may be better suited to your situation. The next issue with estate planning that I see frequently is not funding the trust. Creating a trust but failing to transfer assets into it can render the trust ineffective. Remember, the trust only protects assets that are properly titled into the trust. If the property is not properly transferred to the trust will not work to keep your assets out of probate as you have planned. So how do we ensure that those assets are properly transferred? Well, real estate requires a deed from the current owners to the trustees of the trust. Car titles must be retitled into the name of the trust by taking the titles and the certification of trust to the License Bureau. Bank accounts and investment accounts must be retitled into the name of the trust. This is best done by, again, making a trip to the bank, taking the certificate of trust to the bank officer, and making sure the title of the accounts are properly changed to reflect that the trust is now the owner of the account. Personal property may be transferred to the trust by an affidavit signed by the trustor or the grantor, the person transferring the property into the trust. This can be for any personal property that does not have a title, such as household goods, jewelry, farm equipment, etc. The next issue I see with estate planning is making the estate plan too complex without clear reasons can confuse trustees, executors, and beneficiaries alike, leading to potential legal challenges down the road. If you don't understand the documents, it's a safe bet that others will not understand it either. This is setting up problems for you and your heirs. Next, relying solely on a will. While a will is important, it should be part of a comprehensive estate plan that includes other tools, like perhaps trusts, powers of attorney, and healthcare directives. Remember, a will must be administered by the probate court. Avoiding probate is why most folks do the estate planning in the first place. 6. Beneficiary designation mistakes. Not updating beneficiary designations on life insurance policies, retirement accounts, and other financial instruments can lead to conflicts and unintended beneficiaries. Life changes and evolves, and your beneficiary designations may need to change as well. Is your ex-spouse still a beneficiary of your life insurance policy? Did you take out a life insurance policy when your first child was born, but now you have additional children? Perhaps your spouse was named as a beneficiary, but that spouse has predeceased you. If so, the proceeds of the life insurance policy may have to be probated because it defaults to your probate estate if there are no living beneficiaries on that life insurance policy. Any of these situations and countless others could result in consequences that you did not intend at your death. Number 7. Naming too many beneficiaries on a beneficiary deed. A classic example of this mistake is the older gentleman who came into my office after his wife passed. Several years prior, he and his spouse had gone to another attorney for some estate planning. The other attorney suggested and prepared a beneficiary deed, leaving the property to the couple's children at their death to keep it out of probate. Now, there's nothing inherently wrong with beneficiary deeds, and in some circumstances, they can be a useful tool in the legal toolbox. In this case, however, the gentleman and his spouse had 9 children, and not all of them got along with the others. When I explained that all 9 children and their spouses would have to agree on who to sell his property to and for how much after his death, because all would have to sign a deed if his farm was sold, he quickly realized this was not a good plan. While the beneficiary deed may have, indeed, kept it out of probate, it probably would have resulted in other, more expensive litigation down the road. 8. Making someone a joint owner on your bank account. Again, this is not always wrong, but extreme caution is involved. Making someone a joint owner on your bank accounts means that they can withdraw some or all of your money out at any time without your permission or signature. I've had more than one client come to me in this situation. They thought they could trust the person that was named on their bank account, but now their bank accounts are drained. There are better ways, such as beneficiary designations on the bank account, so that the accounts, while you are alive, stays in your name, but passes to the beneficiary only upon your death. Number 9, making someone a joint owner on your real estate. This may be okay, but do you know if you decide to sell that property, the joint owner must consent and sign the deed as well? If the new joint owner doesn't agree with the sale, they can hold your property hostage. Sometimes litigation is the only way to resolve this one, and we know that is not quick, and it can be a very expensive proposition. 10. Not having your real estate deeds prepared by an experienced attorney can result in unintended circumstances. Did you know that there are multiple ways to make another person a joint owner of your property? Joint tenancy with the rights of survivorship means that if one owner dies, the other owns the entire property. Tenants in common, a different way of holding title, is where each party owns 1/2 interest in the property, and if one party dies, the deceased party's heirs will take ownership of that party's share of the property. That share does not pass to the surviving tenant. Why is this important? Well, the intent may be to add a child or other person on the deed, thinking the property will pass to the other at the death. It may create a situation where only 1/2 interest in the property is passed to the joint owner, but the remaining 1/2 interest ends up passing to unintended distant relatives. Trust me, it can and does happen. So, to wrap up this episode, I just want to encourage you to consider talking with an experienced estate planning attorney when it comes to making sure your loved ones are taken care of when you pass. Even if you think you have everything in place, have someone you trust look over all of your documents carefully. And remember, estate planning is not a one-and-done kind of thing. Life happens, situations change, and your estate plan should evolve as well. Thank you for listening today. I hope that you have found this episode helpful. If you have questions about leaving a legacy that continues well past your death, please reach out to us at www.wheelandlaw.com. We will also put our contact information in our show notes. As a reminder, if you hit the subscribe button, you will automatically be alerted when a new episode airs. If you enjoyed this episode, please give us a 5-star review and share it with your family and friends. As always, my friends, grab a cup of coffee or your favorite latte, hold your loved ones tight, and have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.